we are going to discuss defenses in criminal law. If time allows, I will also handle statutory interpretation briefly, if time honestly allows. Yo, Badman, law school made easy. Didn't know live. Law school made easy. Yeah. So we are going to discuss all the defenses. I want to summarize because I've been told a few people, I think UC will begin their exams on Monday. So I'm going to summarize for you these defenses to give you what we're discussing. Yes, Barbara, I'm going to do defenses, but if time allows, I will catch on statutory interpretation. Many people have been sending me messages about statutory interpretation. Of course, there is a video, but I want to summarize it for you. Those three, I'm going to summarize them in this video. But for now, let's begin with the criminal law. I want to discuss and let you know how these defenses operate. When they ask you a question, what do they expect you? How are you, Kalule Gerard? Yo, what's up? Big up. What's up, Kalule? Thank you, though. So, when they ask you about defenses, how are they asked? What do they expect you to write? So I am going to tackle every defense and I'll give you scenarios of different questions. Normally this session is for 30 minutes, and because colleagues are going for exams, we shall exceed the 30 minutes. Live from USA. Oh yeah, thank you. And we have gone international these days. Every time I come live, we have people from the US who are watching. Thank you for following. Keep following these videos. So let's enter straight into the criminal law defenses. Like I said, I am going to discuss with you how these defenses are asked. I'm going to give you scenarios. What lecturers expect of you when they ask you these defenses. So in a few, we should be able to start. So by now, I am assuming we all know. By now, I am assuming we all know where these sections belong. First and foremost, under Section 6 of the Penal Code, there is ignorance of the law is not a defense. That was scrapped off. It is no longer necessary in our laws in Uganda. So we shall begin with the Section 7 of the. We shall begin with Section 7 of the Penal Code Act, which is claim of right. Now, when they ask you a question and they want you to bring out claim of right, the defense in there is claim of right. These are the things you must look at. Now, these defenses, every defense has an element. Colleagues, let me make a disclaimer before I even start. Never write in an exam and you say that this person would have raised this defense. No. Give the examiner the defense which is there. The examiner has set that question with the defenses that he wants you to identify. So if you don't understand the meaning of these defenses, it may be very hard for you to identify it when the question comes. Now, if you want to be able to identify defenses in a problem question, the first thing you have to do is to know the elements of every defense. When you read a question down and it tells you that, for example, you read a question, it tells you that identify the possible defenses. The moment you see that question saying identify the possible defenses, it means that now you tell us which defenses are there. So don't say a defense which is like it would happen. That is number one. Number two, let's go now to the defenses. What you must take home, every defense has elements. So you look out for the elements. When you're reading a question about defenses, I am repeating myself because I know what I'm talking about. When you're reading a question about defenses, what you must do is have all the defenses rhyming in your head. As you read the question, you say, now, let me first see if there is a claim of right. You read, you say, no. From the elements of claim of right, it is not there. Mistake of fact, it is not there. Insanity, it was okay. You can see this one, insanity is there. That is how you read. All the defenses on that one question should be running into your mind. Automatism, compulsion, all of them. Don't just read. Don't assume. People get excited. You read the question for the first time and then he's like, here I think there is insanity. Excuse me. We have asked about diminished responsibility. Don't hurry. We are saying that there is an abnormality of the mind which is permanent. In insanity, we have what we call disease of the mind, which is temporary. So don't panic. Don't panic. When you panic, you say, I've read, I think it is insanity. No, we are asking you about diminished responsibility. So you must be able to identify. Don't rush. If you want to pass the paper of criminal law, don't rush. You must have read as many cases as possible. So now let's go to these defenses. What do you expect? What do we expect you to read, to analyze these defenses? Like I said earlier, every defense has an element. So the elements of claim of right is where we are now. The elements of claim of right, they include honest claim of right without intention to defraud. Honest claim of right without the intention to defraud. This is a defense of property. Now they are telling you there should be honest claim of right without the intention to defraud. What are they telling you? That when you read that question and there is a claim of right, look at the scenario which has been given to you. Has this person taken somebody's property thinking it is theirs? Is it the honest claim? Then go to another one. Okay, if it is honest claim, thank you very much. Let's push to another one. Was there intention to defraud? Read the question. If you see that in the question, this person intended to defraud, there was safety, this was not his, he intended to take somebody's property, then the defense of claim of right cannot stand. It can only stand if there was an honest claim of a property, honest claim of right, that this property belongs to me, yet it doesn't. There should be some bit of mistaken, okay, without the intention to defraud. So when you're looking at claim of right, focus on those ones. Focus on those ones. Let's go to another defense. Let me cross to insanity. Insanity. The defense of insanity. You can write for me the defenses there that you want us to tackle. Secondly, give us a hands up. Just put on that hands up a like on our videos. Just give us a hands up on our video. So let's continue. Insanity. Never discuss the defense of insanity minus writing section 10. Section 10 is what starts. The moment you identify that there is insanity in this question, you begin by writing section 10, which says that it is presumed that everybody is of sound mind until that time when they prove the contrary. That everybody is of sound mind until that time when that person proves that they are not of sound mind. You understand? So section 10 is what you begin with the moment you are discussing insanity. The moment you start discussing insanity, I repeat, you begin with section 10 of the penal code. The moment you don't write it, what you are writing is a love letter. What you're writing is what others will call BS. Okay? So, make sure that you begin with section 10 that says everybody is presumed to be of sound mind. You are telling the examiner that everybody is presumed to be of sound mind until that time when they prove the contrary. Meaning that you are going now to assess the question. At the time when you read the question, you assume that person is of sound mind until that part the examiner has given you that shows this person is the mad person. Then you enter into section 11 of the penal code, which says that someone will not be criminally responsible if jobless, we just finished them right. If someone will not be criminally responsible if at the time of commissioning the offense, listen, at the time of commissioning the offense, they were affected by the disease. The disease affected the mind, the disease of the mind, and they could not understand what they are doing. That is when someone cannot be responsible for insanity. I want to repeat. You cannot be held responsible for insanity if at the time of commissioning the offense you were affected by the disease of the mind and you cannot know what you're doing. That is the only time when you cannot be responsible for a crime. However, the act says, but you can be responsible for the crime committed even when you are affected by the disease of the mind. But at the time of commissioning the offense, you could know what is good and what is bad. Tuko pamoja? I'll repeat for you insanity. Insanity only occurs. Somebody, if you raise the defense of insanity, it can succeed if the defense lawyer proves to court that their client, at the time they committed the offense, they were affected by the disease, and that disease affected their mind, and they could not differentiate between good and bad. That way, you will not be liable for the crime committed. But the act has a but, okay? You can be responsible for a crime committed even when you are affected by the disease of the mind. For as long as you can differentiate between good and bad at the time when you are committing the offense, you will be responsible, even when you are affected by the disease of the mind. Okay? Now, there is a locus class case for insanity. I want to repeat this. Never write insanity minus discussing the Mark Newton's case. That case was the first case of insanity. The House of Lords sat and they came up with section 11. What you see in section 11 of the Penal Code is the holding of Mark Newton's case. I repeat, section 11 is the holding of the Mark Newton's case. Even when you have never read that case, you can say it was held in the case of Newton that is somebody, you now put section 11. Because that is the holding. The way, if you remember what I told you in consideration, the case of Chudi versus Misa, the holding of Chudi versus Misa is the definition of consideration under the Contract Act Section 1. So there are some cases which are locus classicus. You cannot write minus them. Okay? Now that is insanity. From insanity, I will go to diminished responsibility. Because I want to differentiate between insanity and diminished responsibility. Diminished responsibility as a defense, section 177, sorry. Diminished responsibility, I want to repeat, colleagues. Diminished responsibility is a defense only available for murder. I beg your pardon. The case of insanity is Newton's case. Newton. Okay? Now, but guys, give us a thumbs up. Just give us a like if you like the video though. Okay, let's continue. I wanted to discuss the diminished responsibility because I want to differentiate it with insanity straight away. One, diminished responsibility is a defense only and only available for murder. That defense does not go to somebody who has stolen the beans. Defilement, no. It is a defense available for murder. So when does it occur? The moment somebody is found guilty of murder, that the moment prosecution proves beyond reasonable doubt, and they confirm there is murder, and the accused is the one who committed the offense. Listen carefully. The accused will plead diminished responsibility. The burden is on the defense lawyer to prove that their client committed the act of murder, but with a diminished responsibility. What do we mean? That's why they say guilt of murder, but with the diminishing responsibility. What do we mean? That the accused was faced by an abnormality of the mind that retarded his thinking, and he ended up killing somebody. Arrested his actions. That he was affected by the abnormality of the mind. This one is permanent. Now, the difference between insanity and diminished responsibility. Insanity is temporary. Diminished responsibility is permanent. On certain occasions, colleagues, on certain occasions, they are going to ask you, especially if you are discussing insanity, they will tell you, Professor Walusimbi, Professor Walter was once in Butarika, but now he has gotten treatment, he has left, he is now okay. He has killed somebody. They are asking you insanity, because insanity is temporary. You can get well, and then the other day you are not well. Look at the Contract Act. In what we call lucidity intervals. There are times when you are okay, you can contract. When you are not okay, you can't contract. Now, this one happens for insanity. Insanity is temporary. But diminished responsibility is a permanent abnormality. So, when your client has been found guilty, then the burden shifts to the defense lawyer to prove to court that my client committed this murder under the retardation of the mind. His actions were arrested. He could not know what he's doing. He has an abnormality of the mind. The moment the defense lawyer proves that this person is not left free. He will be sentenced, punishment reduced to life sentence, and taken to a government facility to receive treatment. Life sentence. A colleague was asking, does he serve and go home? He cannot go home. It is an abnormality of the mind, meaning if you leave him go home, he may kill others. So you are reduced because the punishment for murder is death. So now we reduce to life sentence and you're put there. So the question is, what happens to the people he has been convicted with if there are others, accomplices, who were part of that murder for them and they are not under the diminished responsibility? For them, punishment will be served upon them. Hope you have understood the difference between insanity and diminished responsibility. Let me go to compulsion. Guys, look for the cases. Let me go to compulsion. Compulsion. Thank you, sir. I beg your pardon. Okay, let me go to compulsion. Section 14 discusses compulsion. But listen the elements of compulsion. Compulsion means that you are compelled to commit a wrong, a crime. You are compelled, you are forced. Now, one of the elements that is that you must have been compelled. 1, 2, there must be imminent danger that is about to happen to you if you don't do that thing. Colleagues, listen. There must be imminent danger. Danger is about to happen to you. And that should be fast. We can't tell you, if you don't do this, we are going to kill you. And then we first go to town. And then we come back after 2 hours. And you say I was compelled. It doesn't work. It should be very fast. Do this. You don't do this, we are killing you. So you commit a crime. But when you are under pressure, under force, because you're fearing something wrong, something bad is about to happen to you. So as you read the problem questions, look out for that element. Was this person under pressure? Was there something that was going to be done to his life if he did not do a particular activity or a particular act? I don't know. So that is compulsion. It should be fast, heat of passion, and there must be fear of imminent danger that is about to happen to you. Okay? So, as you read the questions under compulsion, this is how you go about it. Let's go to provocation. Write for me the defenses you want. I may forget them. Let's go to provocation. Provocation, sorry, let me give you a case on compulsion. There is a very good case. Reverend Father Kabishenga, Uganda versus Reverend Father Kabishenga and Sister Nyakato. Uganda versus Reverend Father Kabishenga and Sister Nyakato. It was a Western Uganda case. This Reverend, they had told him to stop doing his group, to stop the activities of the group of sisters he had formed, and he felt bad, so he was threatening to kill the sisters. So he tied the ropes among the sisters and told Sister Nyakato to pull the rope so that we can kill these ones. Sister Nyakato refused. And then he told her, if you don't, I'm going to kill you now. So Nyakato, under pressure, she pulled and they killed these ones. Reverend was convicted, but Sister Nyakato pleaded the defense of compulsion, that I was under pressure. I refused, but there was danger happening to me. They were going to kill me, so that's why I was able to do this act, and it was the defense too. So that case is very good. Reverend Father Uganda versus Reverend Father Kamshenga versus Sister Nyakato. So let's now go to provocation. Colleagues, listen very well. Provocation is only and also only available for murder. No, not after murder. Provocation, there must be a dead body. When you read the question and you don't see a dead body, provocation is not there. Provocation, there must be a dead body. If you read the problem question and you find out that there is a dead body, provocation will come. Provocation like compulsion also. Marion, you're welcome. Provocation like compulsion also. It should be very fast. Heat of passion. It should be very fast. You can't say, I was provoked, you go to Mukono, you come back. And then you beat someone. It should be very fast. But two, these are the important things. It must be one on somebody under your immediate care. For example, if you picked if someone attacked my children and I react by killing them, I'm protecting my children. Immediate care. People under your immediate care. That if you commit a crime, but you are trying to save people under your immediate care, you can raise the defense of provocation. Number two, people you have conjugal right with. It could be your wife. It could be your girlfriend. When you're protecting such people, immediate care would include your parents. But you can't come, you are moving, you find people fighting, you intervene, you kill somebody, you say we're provoked. Why? Do you even know those people? Is the question. So provocation has where it occurs. Under those circumstances. Two, if you kill somebody when there was unlawful arrest, you can't say I was provoked. The moment they come to arrest you and you resist arrest by killing somebody, say I was provoked, it cannot happen for as long as there is a lawful arrest. Okay? So that is how provocation occurs. But there must be a dead body. If you don't see a dead body in the question, provocation is not there. Let's go to which defense there? Okay, what if you're protecting yourself? Let's go to self-defense. But I want to give you a good case for provocation, self-defense. There is a good case for provocation and self-defense. Write this case. Uganda versus Ivan Kamyuka. Read it. Uganda versus Ivan Kamyuka. If you're discussing self-defense, provocation, that is Lucas Kaskas case. Uganda versus Ivan Kamyuka. It happened here in Angenoa here. So find out about that case. I won't give you details because of time. Let's now cross to self-defense. Self-defense, I think, is under section 15. But listen, self-defense also, you must prove that there was an attack on me and I was defending myself. That is self-defense. Two, it also should be very fast. Heat of passion. it should be very fast. For example, you can't say it was self-defense. If I annoy you in the morning, you go to Kampala, you come back at 6, and then you beat me up, you say it was self-defense. No. It should be very fast. Heat of passion. There's heat of passion. You understand? 2, the act must be proportionate. For example, I cannot be holding a stick and you retaliate by shooting me using a gun. That is not self-defense, is murder. I came with a simple stick. You are holding a gun that you're defending yourself. It cannot happen. The act should be proportionate. Okay? Somebody can't be having a slipper, using a slipper to attack you, and then you get a panga. It is not proportionate. You can't say this is self-defense. It cannot. It cannot happen. The acts should be proportionate to each other. Okay? So, the case of Uganda versus Ivan Kanyuka is locus cascas for self-defense, and I want to discuss the case you like most Sultan Majinga, but it will become Mr. Gofak will come last. Let me discuss another defense, which is necessity. Necessity is not in the penal code. It's a common law defense, but they like it so much. They like asking you about it in your questions. Now, the defense of necessity, to begin with, for it, you must be preventing a greater harm from happening. You can only raise it if you were preventing a greater harm from happening. Okay? You are preventing a greater harm from happening. Tuko pamoja. Now, because you're preventing a greater harm from happening, your acts must show. I'll give an example. Write the leading case. R versus Dudley and Stevenson. These people were at the sea. They got lost at the sea. So they were there for many days and they became hungry. So Dudley and Stevenson, they decided to kill a young captain who was with them, to eat him. So they ate a person, in other words, not to die. So when they came back, matter went to court. They raised a defense of necessity, saying that we ate him because we were going to die, we were hungry. So the judge was very clear. The judge said, you cannot raise a defense of necessity if you are selfish, if your act was selfish. In other words, why did you choose one of you to die instead of him? Why do you care another person? So they were not preventing anything big from happening. They took away a life of another. So this defense happens if you see that somebody did a crime, but he was preventing a greater harm from happening. Let me give you an example. I've always given it in the video. When they say at UCU that when you break a window, you bring a new one or you pay. Then fire guards, and then there are children in that room. But the only way you can escape the fire by breaking the window, and you break the window to prevent the children from suffocating, from dying. There you can say, I raise the defense of necessity. So for every defense, you know, when can I raise it and when does it fail? Which other defense am I leaving out? A mistake of fact, Sultan Majinga, that one you know. Section 9, please appreciate it. Accident. Accident the way it is. Wilmington, DPP versus Wilmington is the case for accident. that you must not be intentional. You did not intend to commit a crime, but you end up committing it. You never intended. Okay? Automatism, you're not in control. Okay? You're not in control of your acts. Okay? That's when we can come to that defense of automatism. So those are some of the defenses. Okay? Duress. Audrey, duress, criminal law, contract law, and also here, okay. So those are some of the defenses. Those are some defenses. Now, briefly, because it's getting late, briefly, I want to discuss the statutory interpretation in this video. In just 4 minutes, I want to discuss statutory interpretation in just 4-5 minutes. I'm going to summarize it just to go and get cases. Listen to these 3 I'm going to discuss. From here, just go and add your two cases, advantage, disadvantage, and you go. We begin by the literal rule. Now, statutory interpretation. Let's begin with the literal rule. In the literal rule, they are telling you that as you interpret the statutes, give them their literal meaning. Give them their meaning, what they mean. Don't change. But the most important about literal rule, they tell you that even when it is leading us to absurdity, let us go there. Don't change the meaning of the statute. Even when it is leading us to problems, you say that when I interpret like this, we are going to get this problem. The rule says that if you are applying the literal rule, give the words their meaning. Don't change anything. Give them their meaning. Even when we are going to problems, let us go to those problems. Don't change anything. That's all they want. Just explain that. And then you give the cases. There is a case of a Chapman. There is an English case where someone was killed because of a comma. But it is because they were giving the word its literal meaning. And somebody was killed because of that comma. I forget the case. But the case is there. So when you are dealing with literal meaning, this is what you write. That when we are interpreting the statute, we must give them their original meaning, without changing anything. Even when it is leading us to absurdity, it is okay. Let it lead us to absurdity. No more, no less. Then after doing that, you give the advantage and disadvantage of literal rule, you are done. And the 2-3 cases. Let's now go to golden rule. Now, the golden rule, you begin by saying, this one came to remedy the literal rule. That, let me please briefly discuss about the remedies of breach of contract in the contract law. And kindly also, please, thank you. Now, when we go to golden rule, now under the golden rule, they are telling you that the golden rule came to remedy the literal rule. For it, it states that let us give the statutes, the words, their meaning that does not lead us to much absurdity. Let us prevent the absurdity. Let us interpret the words. We interpret them giving them the meaning that does not lead us to much absurdity. In the literal rule, we are saying, even if we are going to absurdity, let us go there. In the golden, we are saying, let us minimize, let us reduce the absurdity. So give them the meaning, the other meaning. You can opt for the other meaning, not to lead us to absurdity. That's when you apply the golden rule. Because they noticed that the literal rule had given us issues. Okay? So now, we now had the golden rule. Hope we are okay with the golden rule. It doesn't lead us to much absurdity. Reduce the absurdity. Reduce the dangers that we can go into. Then we have the mischief rule. Now mischief is very interesting. Mischief, the word itself means problem. Now under mischief, this is what they're telling you. Identify the problem. When you identify the problem in the statute, for example, this statute, or this one, land law, sale of good, land law, they are saying that in this statute, identify the problem. If you see the problem, you go back to the intention of the framers, the lawmakers. When members of parliament were making this law, what was the intention of the members of parliament when they were making this law? Now, when you get the intention, where do you get the intention of members of parliament? In the answered. Now, if you go to the answered and you get their intention, what they intended to mean when they enacted that particular law, okay? The moment you get it, you now come back. You replace the problem with what you got in the answer. That is mischief rule. I want to repeat it. The mischief rule of interpretation is that identify the problem, look out for the intention of the framers, of the lawmakers when they were making that law. What did they intend to achieve? When you get it, you now come and you suppress the problem, you replace it with the intention of the framers. Okay? Give us a thumbs up, guys, if you feel it's a good video. Now, colleagues, hope you understand. Identify the problem under mischief rule, look out for the intention of the framers, suppress the problem, and then replace it with the intention of the framers. That's how the rule operates. Then you give advantage and disadvantage. Golden rule, advantage and disadvantage. The other one, advantage, disadvantage. And then you run away. Plus three cases on each one of them. So read the cases, appreciate the cases. So that is the statutory interpretation. So I know there are very many questions, but what we are going to do, I will make sure tomorrow I'm here on time. Normally why I don't do at night is because I come back late sometimes. So but tomorrow I'll make sure I come back early. And when I come, we shall start with those questions which I have seen there. Because it is getting late and I think I'm also getting tired. It's a little rest. But give us a like. Just give us a like if you like the video. Just hit on the like button. It's just, you lose nothing. And we thank you for following, for always liking our videos, being there, watching them. We are there. Put the comments on those videos. That's why we pick some of these things. Like today, I saw a comment for us to do the defenses and statutory interpretation. So keep the comments coming. We appreciate. Also, subscribe to our channel, the other one, Voices of the Bar. Subscribe to Voices of the Bar, and this one, Law Schoolmen, is there. Both our channels. Make sure you subscribe, turn on the notification bell, so that every time we put up a video, you are able to follow. But tomorrow, I think people need more time. Tomorrow I'll come earlier, like 9:30 or 9. Then we can do up to 10:30. I think, yeah, I'll come earlier. We'll do like an hour or 1 hour and a half. I'll come earlier and then we discuss most of these things. We thank you so much. Until next time, see you. Cheers.